DeAndre Coates for the Attorney General's office, Your Honor. This case has been pending for a while, Your Honor. We did do temporary orders back in October 11th of 2024. So Ms. Pierce was here in court because that was a heavily contested case at the time. The last time I believe we were here was, let me see, I want to say March 7th, Your Honor, maybe March. Yes, I think March 7th. And which at that time we wanted to proceed with finalizing the temporary orders. However, Ms. Pierce wanted a reset so that she can get an attorney. At that time, when she signed into court, Your Honor, she was in Hays County Jail. And so the Hays County Jail did sign her in, and we put the reset because it was a contested reset. So that was put on the record. Your Honor notified her. We also mailed a copy of the reset to the county jail, and we also contacted them to give them information on how she can sign in. And we did confirm with Hays County Jail. She is still in Hays County Jail at this point, and she has not signed on, Your Honor. So we are asking to move forward with making some small changes to the temporary order in order to finalize it.
Okay, but the order did say that she could appear if, even if, I don't remember what the order said, but somehow the jail knows that she had a hearing today.
Yes, Your Honor.
Okay,
Yes.
they've not made her available, or she's not availed herself of that ability to show up through the jail.
Correct, Your Honor. Correct. And then to our knowledge, she hasn't obtained an attorney or either. And there's no knowledge that maybe the attorney's running late or something.
Well, I've got to figure out if she knew how to appear by jail, then it's the same jail that she would have advocated for herself and requested to appear or insisted, even if the jail didn't know. But I assume they did because they were actually, I don't know if they were listening last time or not, but if you communicated with them, did you actually, you just communicate or found out that she was there, but not necessarily to verbally tell them?
Our technician, Raven Aguirre, she called the jail to confirm that she was there. And then she did send a email on the instructions on how to follow up with signing up to Zoom, just the way we did last time when we came in March. So we gave her all these same instructions.
Same instructions.
As March.
But they went to the NCP mother, not the jail. Which is, or did you also send it to the jail?
We sent it to the jail where mom is.
Okay.
Yeah. Sorry.
No, but they got it for her, and then they would have given it to her. So they both would have known about how to log on if they really wanted to. I'm just trying to figure out exactly what you did. You sent it to the jail for her. Would they have been able to open it, or it was just to deliver to her without? Or do you even know that? I'm maybe trying to beat a dead horse. I just want to make sure that there's not going to be any reason to open it on this default for any reason. So you gave notice, and the notice was to mom, but somehow you confirmed that that she was still in the jail, but the jail got it. I'm just not sure how they get to know about it.
Okay, so when we were here for the reset, when Your Honor granted it in March, I had Raven mail that reset to mom at the jail.
Yeah.
And then
well, that's all that's really required then. I just didn't know if it was...
then yes, and then like I believe earlier this week I double checked to see if she was in jail, and I asked Raven Aguirre, our child support technician, to just double check that she's still in Hays County Jail. She is. And then they sent an email. I'm not sure which email Raven Aguirre uses to email that judge on, or not judge, that Hays County Jail on how to sign up. But she sent the exact same email that she sent from March to today.
Okay, so you sent it really to two entities, both the mom at the jail and to the jail.
Yes.
Okay, then abundance of caution, you've covered all your bases. That's what I was trying to get at, just for the record. Sounds good. And now I've wasted a few more minutes doing that. It's 11 o'clock and they're still not logged in, so we'll proceed by default. anything further in the way of your opening statement?
No, well, Your Honor, did you want me to go over the temporary orders, and then
I'll
tell you where the changes we're asking to make?
I don't mind if you just do it through testimony, what you want today, and then you tell me at that point what we did different, the parts.
Okay.
And that would be
Okay.
the best time instead of you telling me and then him telling me.
Okay. So part of the opening, Your Honor, is that we're asking that, they remain, the conservatorship remain as sole managing
Okay.
conservatorship with Mr. Smith being the sole managing. There is a restriction to geographic restriction to Comal and contiguous counties. Mr. Smith is also asking that electronic communication be the only form of visitation at this point, which previously what was ordered is that Ms. Pierce shall have electronic communication with the child via Zoom, Facebook Messenger, or any other app that allows FaceTime-like communication. Electronic communication shall begin October 16, 2024. Electronic communication will be every Wednesday and Saturday from 5 p.m. to 5:30 for at least 20 minutes. Mr. Smith shall set up the meeting for the designated time and date. So he's asking that the electronic communication remain as is, and that the in-person visits should be removed, which is the visitation once a week up to 2 hours at Guardian House with the address listed on there. Times and days are subject to Guardian House scheduling. Ms. Pierce and Mr. Smith will split the costs. Mr. Smith shall attempt to find supervision center closer to Ms. Pierce or a competent adult of Mr. Smith's choosing to supervise the visits. He's asking that that be removed, Your Honor.
The entire person visitation. Okay.
Yes, the entire in-person visitation. App
Tell me,
closed.
remind me how old the child is that I don't remember. It is an older child?
No, she's 4 years old, Your Honor.
Oh, 4, a younger child. Okay, thank you.
Mr. Smith is asking that app close remain in place.
Okay.
And Ms. Pierce, the state is going to ask that there is a finding that Ms. Pierce has no income since she's been incarcerated, Your Honor. My understanding is that she's been in jail since November, Your Honor. And so we're asking that there's a finding of no income and that current child support and medical support be set to 0 at this time. Mr. Smith continue carrying the child on government insurance. And then let me just double check, Your Honor. I believe Mr. Smith in the temporary orders. Well, actually, I think Mr. Smith is not asking for any retro support at this time, Your Honor, or at all. And that wasn't addressed in the temporary orders. And then let me just double check, Your Honor, if there's a non-disclosure in place. Yes, Your Honor ordered a non-disclosure. Mr. Smith is asking that that remain in place. And court costs were reserved for a final hearing, Your Honor, so we will defer to you on that. All right, Your Honor. Let me call
Okay.
Mr. Smith. Mr. Smith?
Yes, ma'am.
All right. I know that was a little long, so I'm going to break it up. Are you asking that the conservatorship in which Judge Madrigal ordered previously remain in place, which is your sole managing conservator, so you don't necessarily have to reach out to her and let her know what's going on with regards to your child's health, but you are the one who makes all the decisions?
Yes, I am asking for conservatorship custody.
Okay. Then you're okay with a geographic restriction to Comal and the counties that touch it. That just means you and the child shall reside in Comal or the counties that touch it.
Yeah, yes, for now. But if she gets a very long prison sentence, I would ask that to be changed later. I would take it to a judicial court at that point.
Okay. Well, let me ask you this. Instead of having to wait that long, would you prefer no geographic restriction, given that she has been in Hays County Jail since November of 2024? And I believe she may have charges in another county. Is that correct?
Correct. So she's got multiple charges pending, and also she's most likely going to be charged with molestation of my 14-year-old boy in Comal. So I would like no geographic restriction, and the reason being is this has been a big thing in our community, and I just would like to start over.
Okay. So you have plans to move, and you would like to be able to move.
Maybe to Kansas, a peaceful place like Kansas.
I think I won't rule yet, and I may need to hear a little bit more testimony that I might hear when you reach the part that you're asking me to do no specific in-person visits. At that point, maybe I can remove it at this time if she's in jail and can't even access a child anyway. And under other circumstances, I might. Granted, but I don't know yet. To make sure I remember to tie that to the visitation.
We'll come back to that, Mr. Smith, in just a moment, okay?
Yes.
Okay, so you're asking that you continue to be able to communicate with her via app closed whenever she is released, if she is released.
Yeah, correct. I would like Kaylee to know who her mother is, but this woman is she's highly irresponsible.
And then you understand that since she's been incarcerated since about November of 2024, and she hasn't been released, that we do need to set current child support and medical support to 0 because she's not making any money right now.
All I care about is the custody of my child. I don't care if I ever receive a dime.
Okay.
I don't need it. I don't want it.
Okay, and so same thing with the retroactive child support. You're not asking for it.
Not a dime.
You've been
I'm
able to
sorry.
take care. No.
I didn't
You've
mean
been
to
able to
interrupt.
take care.
Sorry. Yeah.
That's okay.
Yes, I've been meaning to. Yes, I'm more than able to take care of Kaylee, and I just I don't need it. I don't need it. Don't want it.
All right, and then Kaylee is covered on health insurance. How?
Through Medicaid.
Okay, and that's through you. You're carrying that.
Yes, I'm carrying the
Okay.
Medicaid. I have Medicaid as well.
Okay,
As a single-
and does your job remind me again? Does your job offer health insurance at a reasonable cost, or are you self-employed?
No. I own a contracting business.
Okay, so
Self-employed.
self-employed. All right, so no access to private health insurance at a reasonable cost, correct?
Correct.
All right, so now we're going to talk about the visits. All right, so before Miss Pierce was sent to jail, had she exercised any of those in-person visits?
None. Not any attempt. As a matter of fact, even the video visits, I believe she appeared at 2, 3. She appeared at 10. She had 3 out of 10 that we scheduled, and out of those 3, she was late twice.
And she was late, but how did they go? Like, did she do the whole 20 minutes? How did Kaylee react? Was like how were those video calls?
I mean, they went as well as expected. Kaylee has an idea of who her mother is, but she does not have a kind of a mother-child relationship with Tracy. And I will say that she didn't even have that when Tracy was here and present. I did.
And then so since she hasn't been able to exercise the in-person visits, when was the last time she saw Kaylee in person? If you don't remember, you don't have to give an exact date.
Yeah, it's
your family is welcome to watch, but your family cannot talk or testify if you don't remember.
No. It's I would say it's a little closer. It's April. It's around April of 2020, 2 years ago, 2023, I believe.
And if I remember correctly, I know there was a whole incident where police were called to your home and or she brought police or something like that. Is that the time frame in which that happened and that's when she last saw her?
Right. Yeah. She had brought police to the house to get her quote unquote belongings, which we had already had offered to her personal belongings, but she was trying to get much more than that. But yes, believe it was some 2 months before that date that she had seen Kaylee in person.
And do you remember how that went? Was that also
I,
not a good visit or?
oh no, it was not at all a good visit. She knew the law was about to be called on her. My son had found methamphetamines, uh, and of course, he had not come clean about the molestation at the time, but he had found methamphetamines and ran next door and showed me a picture of a baggie and stuff. And that's when we did all we could to like tell her to leave, and she wouldn't leave. And then she packed a bag a couple of days later and left on her own without telling anybody anything. Kind of snuck off.
And then are you aware of what Miss Pierce is charged with?
Yeah, so her current charges, which I believe this is, yeah, so she's a theft of $300,000 or more. And I've had a private investigator ask a few questions around Blanco and Blanco County and Hayes County. Her and a consortium of people were renting U-Hauls and going from place to place, including homes, car lots, parking lots, and filling these U-Hauls up with merchandise. That's why this theft is so large, $300,000 or more, first degree felony. 2 burglaries of habitation, second degree felonies. These are, I believe, because they're second degree felonies after a certain time in the evening. And then theft of a firearm, state jail felony. And then I think she also has a couple of charges of running a vehicle processing facility, fake titles. And of course, and then there's already been a preponderance of the evidence found by Child Protective Services that she both physically abused my son, Damian James Smith, and sexually abused him. And look, if he had been 1 year younger at the age of 13.
Okay, Mr. Smith, hold on. I know you wanted to get into that and I know you want to bring that to light, but that was things we did talk about in the temporary orders. Now, what we
know, I'm
need to
sorry.
know,
I'm very upset.
what we need to know now is that, you know, since the temporary orders, what things has she done? Obviously, her charges that make her unfit to have visits in person.
I mean, she cannot. First of all, you as a parent, as a human being, right, would make more effort. I mean, she cannot even come to the video visitations on time. You know what I mean? And she her moral scope is very skewed as a person. I mean, she even lied to your honor here about being able to use the video online. And then as far as the children are concerned, she has always cussed them like a sailor. I mean, mentally abused them. I don't believe in mental abuse of adults. I don't believe in it. But a child has no choice of where they're at. You know what I mean? They're there. And she cusses them like a sailor. And I multiple times had the neighbors tell me about it when I'd come back home from work, that she'd be cussing them on the porch. It's just she's not fit as a mother, and she makes no effort. I don't believe she cares at all. I believe she is just using the children as a tool in some way to try to get a lighter sentence, a better outcome. It's a manipulation for her.
Did she use any inappropriate language during these calls? Did she say anything inappropriately about you and your family in these calls?
I believe one time she she said something, I can't remember to exactly what, it was derogatory about her grandmother, or your Grammy, as she's called, her mother. But she was, no, the video visitations, of course, were 20 minutes long. We set them up and they were just start to finish. And she was late most of the time. So you're talking 10 minutes. There's not a lot of time to get it in anything there.
And then, is there, do you have any reason to believe, based on her charges, that she may be sentenced to jail for quite some time, that
Yeah. So
in person's not even feasible?
yeah, well, in person's most likely not feasible, number one. And number two, I understand that she has not been charged. And even thank God the way our Constitution is written, that people are innocent until proven guilty. But a preponderance of the evidence is enough for any civil court, that's 51% or more, that she molested my son. She should not.
Mr. Smith, we're talking about Kaylee, and we're talking about what has happened since then.
Yeah.
Yes. Okay.
But that does speak to her. It does speak to her being.
And so have you been looking to move from your current home to somewhere else? Has that been in the works?
Yes, it is in the works. We sold this property already. We're moving next door to our lot next door, right? But after we get that property built up, we're looking at buying a small school, believe it or not, in Kansas. They redistrict all the schools up there, and there's a 7-room 1954 school that we would like to go and maybe build a fishery there. I mean, the U.S. needs fisheries, so.
I believe that's all the questions I have, Your Honor, at this time.
Okay, is there anything, Mr. Smith, that you believe you weren't asked that you'd like to put on the record, and without details on the charges that I've already heard and I'll take notice of, and I think I've heard some of this before. Anything else that you haven't already said?
I'm a reasonable individual. I would not ask that she not be able to see her daughter if I did not believe in my heart and in my mind that it was the right thing. I believe that no matter my personal situation, I believe every parent should have access to their children in some way. It's not okay to just take people's children at a whim. It is not. She's a selfish woman. And I don't believe she deserves in person at all. And I didn't from the beginning.
Okay, I know this got really messy, and there's some things I kind of do remember, especially from the last hearing where she started blurting out all sorts of, I think, ugly things. I try not to remember most of the stuff because every day is a new day with a new case. And so I'm kind of doing it with this. But since she's not here to defend herself, and I know she's in there for charges and you're not in custody, so clearly, you don't have any pending charges, Mr. Smith?
Yes, I do have a set of pending false charges. And my son came clean about those. There was
just what's the charge, and why do you
there's supposed 2 strangulation charges, which they have video evidence that did not happen, right? And then she said aggravated assault with a deadly weapon. I still cannot find out from Comal County what that charge is. I've bonded out on that charge, and I don't know what the deadly weapon is. I don't know where they got that from. They indicted me 45 days later. Or actually, she went in 45 days later, gave a statement to the DA's office, and then I guess it was 5.5 months later, I got arrested, and I don't know what it's for.
Okay, but no, you don't have any current court dates? You don't?
Yes, I'll be going to court on the 16th of next month. Even a very stickler Judge Steele gave me a 67-day reset because he said that something was amiss, because he wanted me to have time to have a private investigator.
But you don't have a lawyer?
Yeah.
You do
I do.
have. But you think they'll be dismissed then, or?
Yes.
Okay. And there's something ugly or bad or pointing fingers at each other that I just wanted to clear up or try to weigh between you all. But you're the one that's out. You're the one that has the child. How long have you actually had physical possession of the child without mom's presence?
Over 2 years now.
Okay. Was she trying to take the child back somehow surreptitiously at some point, or no, she just left the child with you?
Just left.
Okay. I do remember her asking for custody. I'm not mistaken on that point.
No, you're not mistaken. But again, Your Honor, I don't know a person's heart. I'm no God, but I do believe that is a wholehearted manipulation.
And without telling me the facts again, the charge with respect to your son, you think there is evidence for that and that she will be eventually tried for that?
Yes, absolutely. There's a large amount of evidence. You can go to sexoffendersetup.com.
And Your Honor, I believe, I apologize for interrupting. I had pieces of evidence where we did, I believe, show findings from CPS
I
that,
remember that. Mhm.
yes, that there was some amount of evidence to the allegations. I don't have all of those evidence
No, I don't
available.
need him. You just triggered my memory. I did remember seeing on-screen share of something from CPS that did say something with respect to that, which was not positive to mom, correct?
Correct, Your Honor. Yes, they said that she shouldn't be around his son, if I remember correctly. But yes, there was some findings of possible sexual abuse allegations. So that was in question as well. So they both kind of had like charges against each other,
Yeah.
and things like that. And you did in the hearing back in October ask her why she didn't take the child with her when she brought the cops. So that was another question, Your Honor, on that you did ask her at that point as well.
That sounds like something I would do, and I'm not remembering all the testimony because there's just no way I can. But Mr. Smith, has Ms. Coates said anything that is not correct that you need to clarify?
No. Well, she's speaking the truth, and it is correct.
Yeah, and I actually do remember, I don't see CPS findings very often, but I remember seeing it somewhere, and it must have been this case. And you're verifying that. Okay, I don't think there's really anything else you need to tell me at this time, but one last, anything else? New,
No.
different?
No.
No.
No, ma'am, Your Honor.
Okay, so tell me, you already did tell me, but instead of picking through my testimony, go ahead and give me the order you want. In summary, as a closing, Ms. Coates.
Yes, Your Honor. We are asking that Mr. Smith remains sole managing conservator, asking for no geographic restrictions, continuing app close, setting current obligations to 0 with a finding that she's incarcerated and has no income. Mr. Smith carry the government insurance still. No retroactive, Your Honor. Non-disclosure remaining. And we are asking that only electronic communications remain in place until further court orders. And we will defer to Your Honor with regards to court costs. The state normally asks that she be the one to pay it, but Your Honor.
If they're in jail, I usually don't allow it because it'll take years to collect anyway, so why bother? So court costs are waived. And was she ever a custodial parent in an AG case, or she's never been the custodial parent?
No, Your Honor, she's never been a custodial parent. The testimony was these parties were living together at one point. Then she left without Kaylee, and she even has 3 other kids who live with their other father. So she's never had any of her children.
No, I kind of remember that too. And that's true, Mr. Smith?
Yes, and she's never been responsible for a child. Ultimately, she's been able to visit. That's it.
Okay. Since it's the state and it's not their facts, I just wanted to verify through you that what they're speaking the truth. I think I can't swear to remembering it, but when it did trigger some recollection of that. Okay. What else?
And then, Your Honor, just to further remind you, she actually has no car either. So that was why Your Honor was saying it put in the order to try to find a supervised center closer. But she doesn't even have a car to exercise these visits.
Yeah, okay. I'm convinced it's just, I thought I was gonna have an ugly custody case today because it was ugly last time and the he said, she says with pointing fingers at each other got a little messy. So I just wanted an abundance of caution to not necessarily clear your name because I can't do that. I wasn't there. I'm not the criminal court, but I wanted to know the facts, including what was on your background as well. And you adequately addressed that for me. So having
Your
heard
Honor, may I say, Your Honor, may I speak?
go ahead.
Good, bad, or indifferent. And I know people say this a lot, but I'm honest to a fault. I would tell you the good, bad, and the indifferent.
No, well, what speaks volumes is you had the child for a long period of time and nobody's come taking the child, whether it's the mother or Child Protective Services, especially if they've already been involved. And we're looking at other issues.
Yes, ma'am. I
child
took
has remained
eight
with you.
UAs for them over a 6-month period. And she's all that matters in this world to me.
Okay. Remind me, sir, do you have other children? Oh, well, your son, is he still a
Yeah.
minor, still living with you?
No, I thought it'd be best because the counselor and the school and everybody out here in the country knows now. And it's put a lot of pressure on him. I thought it'd be best for the first time in his life that he go live with his mom at 16. So he's in San Antonio. He's just right down the road from me, about 35 miles.
You do get to see him or do you?
Oh, yes. Yeah.
Do you have a good relationship with him?
Oh, I do everything I can to build it back. He does have a tendency to view us as co-equals now because of it's very odd, ma'am. I want to let you know it's very odd, but we already had a strong relationship. That's my boy.
Okay. Well, they do get to an age and sometimes it's 3. They think they're in charge, but they're not. They'll figure it out. Okay, this was a suit affecting the parent-child relationship with or was it? Let's see, with the AOP.
I believe so. Let me
So all
see.
the findings will remain that he's been found to be the father. He has a duty of support.
Yes, Your Honor.
Yeah, okay. Then having heard the evidence, I'm not going to repeat it, but I am going to fill in some gaps. The start dates on the child support, medical support, and dental support zeros. Is it back to the temporary order start date or something else? I assume that'd be the easiest to keep your computer straight.
Let me see. What were the?
If I saw them on October, they would have been November, but I'm guessing. So you tell me.
Yeah, let's see. 1 second. Okay, so $30 for child support started November 1st, Your Honor.
Oh,
Yeah, November 1st, 2024. So we could do $0 starting today, since
wait,
she's incarcerated, or
$30. Mom was ordered to pay dad.
yes, mom was ordered to pay dad, Your Honor. So child support was set at. So in October, she was still out, or she hadn't been arrested, Your Honor. And because she didn't have a car and she was not getting a lot of hours, the parties had agreed to $30 for child support. So we need to now set it to 0, because a month later, she got arrested.
Can I speak? I'm totally okay with retroacting it to 0. I need nothing from her. I mean,
Okay.
whatever's easiest. I'm sorry. I didn't mean to interrupt.
I
It's
get
okay.
it. No, that helps. However, there's still the matter of the state and their Medicaid money. But tell me again, I didn't hear it earlier. Child support's 30 a month starting November 1st from mother to father. What was medical support and dental support?
There was no dental, because neither party had it, and so you ordered $30 for medical support starting November 1st, 2024.
And did I hear right then that child support was also $30? I'm not confusing the
Yeah, yes, Your Honor. You were talking to both parties. They ended up coming to a consensus that, you know, she couldn't afford it. Mr. Smith said he didn't need that much, so 30 for each was
Okay.
okay.
I guess there's a couple of minor matters I could do here is, the state wanting their $30 a month all the way through, here we are, May, and then zero starts June 1st, or not?
Yes, Your Honor, but we also have no problem stopping it as of today. But June 1st, stopping it would be okay as well.
Well, May 1st already lapsed, so it's on your system, so I don't know if you have the authority to waive it for May, or do you?
Believe she'll still owe it, but we just stop it as of today instead of waiting. I think.
That
Man,
would
it's probably just easier to stop in June. Sorry.
just start at zero on June 1st.
Yes. We do
Okay.
have our system change too coming up, so.
Oh, we don't want to mess with that. We don't know what it's going to do to everything.
Yes.
So the temporary order has 30 a month starting November 1st, 2024, and then this order will have medical support of zero starting June 1st of 2025. So there might be a few dollars that she owes the state for the government program. However, I do want to do the same for everything else. Start zeros now. That's the only way the computer's going to take it. And then if you can tell me what the arrears are as of the end of, well, no, as of today or yesterday, actually. And then he can forgive it. Because that's the only way we can do it now that the medical support can't be forgiven since it's not his to forgive.
Okay. So as of yesterday, Your Honor, she owes $205.88 in child support judgment. This is as of yesterday. Medical support is $211.50. So if he wants to release the child support judgment, that is fine, Your Honor. We'll do a cumulative language where it's saying zero retro. And then a release. I'll put in special language in there. And then
Is that what you want to do, Mr. Smith? She owes, or she would owe, at least $205.88 as of yesterday for child support. You didn't ask for any retroactive child support for prior time periods. So it would be zeroed out as to what she owes you for child support. Are you okay with that?
I think that sends the message I want. Yes, Your Honor.
Okay, then the order will reflect that. So she owes you zero for child support. She still would owe the state the $211.50 for the medical support under the temporary order, but we're stopping that with the next month, so it wouldn't continue to accrue, except for a few cents of interest until she pays that off to the state. And then
the repayment on that would be $21, Your Honor.
$21, okay. It's also starting June 1st, even though it's meaningless or it can't be enforced right now. It could affect at some point. And the dental, since there was no dental in or was it a zero dental order in the temporary orders?
There was a finding that neither parent had private dental.
So it just was not addressed or ordered at zero. Okay, so then we don't have to do that. But Dad, you're not asking for any dental retroactive.
No, Your Honor.
So you can put that in there that's a zero as well. So that's the retro. That's not going to be granted. Okay, I think I got it, and that's all as of May 15th. Today's the 16th, correct?
Yes.
Yeah. I think that covers it for me. I am going to waive court costs if I haven't said it already, and I'll approve everything else. And I think I've got the details I need on the financial stuff, and then I will remove the in-person visitation. Let her come out and prove herself or get these charges taken care of before she has any authority to have any visitation. You know, if she clears up her name and or she's finished her sentences or whatever, you got a very young child, the order does say that at any point that you think you want to do something with visitation, have an agreement with her, even if it's a 1-hour supervised visit for dinner as a 16-year-old. I mean, I don't know. I don't know when she's going to come out of this, if ever, or if she'll be in prison or not. I can't predict that, and you can't either. But for right now, I think it's not in the child's interest to just say, come and get her at any point, even for supervision. But I tell you as a parent that if you want her to know her mother, and at some point there is that opportunity and she's not a danger, not a flight risk or anything like that. If you're in your good judgment, even if you accompany her, some other adult accompanies her, so she's not alone, you can do that and have dinner, you
Yeah,
know.
no, it's the moral thing to do.
Yeah, I've done that with older kids.
If at all possible, it is.
I've done that with older kids that have had no contact and they're kind of like strangers. Well, that doesn't mean you can't meet. That doesn't mean you can't start a conversation. That doesn't mean you might have visits
Just make-
later. It just
Just
means,
make an effort, Your Honor, just make an
Okay.
effort. I'm sorry, I didn't mean to interrupt. That's very rude of me.
no, that's fine. No, that's fine. So no in person, I will continue the electronic communication if that's her only means, and whether she walks through that door or not is on her, but she'll be allowed that. Did you want to leave the exact days, the Wednesdays and whatever that was, Sundays, or just put at reasonable times and for reasonable lengths?
Yes.
We'll leave it as is, Your Honor. And then were you granting the removal of the geographic restriction?
Yes, that in conjunction with the visitation. If she's not gonna have visits, there's no reason he has to be tied to that county. He's not obligated to stay close to her just because she's in the jail here. And where are her other charges? How far away or are they not
They're
that?
all in connecting counties, mainly Blanco, Hayes, Comau.
Okay. But it looks like she has some time to get through all of them. So no, yeah, I will remove the geographic restriction.
Thank you, Your Honor.
I think that covers it from beginning to end.
Yes, Your Honor, that should be it. It's gonna take me some time to draft it,
Yeah.
but I will get it done.
I think we got all the details in there. There's gonna be a bunch of language in there as well. You've seen the prior orders. The law says it has to be in there. We have to put it in there. If you have any questions or anything comes up, you call the AG. But when they get it out, hopefully, well, today's Friday, may or may not do it by the end of the day, Ms. Coates, it might be Monday, or do you know?
I'm hoping to get it out before end of day today.
Okay, well, check your emails if it's there before, it would be there before 5. I hope you don't work after 5, Ms. Coates. And if it's there, look at it over the weekend, sign off on it if you can. If you have questions or concerns, talk it out with the AG. If the AG comes up with any questions, I don't mind if they ask me if I left something out. But if we think we need to communicate with you, the AG would, not me. But it seems like we've covered all the issues. But if there's something we didn't think of and we put it in there, I'll have the state make sure you're aware of it. If
Thank
it's
you.
something different. Okay, then that'll conclude this hearing by default. And against, forgot her name, Ms. Pierce.
Yes, Ms. Pierce, Your Honor.
And I'm rendering the order, which means it's my order now, whether you walk away and no longer agree with it later, it's an order, I'm granting it. And I'm gonna sign it whether you change your mind or not, Mr. Smith, you understand that?
Yes, Your Honor.
Okay, well, thank you. All you need to do is click the end meeting button and then start checking your emails sometime late afternoon. And maybe it's there, maybe it's not.
Thank
Then
you, Your Honor.
thank you, sir. Good luck to you and your children.
Thank you.
Thank you.